All right. Hello, everybody. I think everybody's in and out of the waiting room. Yep. Yep. I'll just assume that that's correct. Hi, welcome back to Docket 251213, application of the Connecticut Light and Power Company, DBA Eversource Energy, for an order to securitize 2018 to 2023 catastrophic storm costs. My name is Tom Wheel. I'm the interim chairman of the Public Utilities Regulatory Authority, and I'm joined today by my magnificent colleagues, Vice Chairman David Arconti, and interim commissioners Jan Beecher, Holly Cheeseman, and Everett Smith. We're here today for an informal scheduling conference, and similarly to the conference we had on January 22nd, I want to start with kind of an overview of why we called this meeting, but first I want to get through some housekeeping. I think most people on here have already heard some version of this, but we're here remotely. This is an informal conference, but we are, I think, on the record. I guess I should ask, do we have the court reporter on?
Yes.
I
Mr.
am
Dixon
here.
is on.
I am
Okay.
here on the record.
Thank you. So we are on the record. So please don't use the Zoom chat function to try to communicate as part of the discussion. It won't make it onto the transcript. For the benefit of the court reporter and the record, if you could remember to quickly introduce yourself and your affiliation before you speak. I'm very bad at that myself, so it's okay if you forget. Please do feel free to use the raise hand function once we actually start the conversation. I'll do my best to call on people in the order in which they raise their hands. In keeping with other recent PURA events, commissioners are the coolest people in the room and can jump into the discussion whenever they want. So commissioners, if you use the raise hand function, I will try to prioritize you. If I miss you, just feel free to unmute and jump in. So why don't we start by just kind of going around the virtual room and having someone from each party introduce themselves and maybe who else from the organization is here to participate. And we could start with Eversource. Attorney Pace, I see your hand.
Good afternoon, everyone. Vincent Pace, representing the Connecticut Light and Power Company, doing business as Eversource Energy, and I'm joined today by my client, Doug Horton.
Thank you. How about OCC?
Hi, yeah, Kim White with OCC, and I'm here with Director Minikowski and Consumer Counsel Coleman.
Hi, everyone.
Good afternoon. EOE?
Good morning, Tom Lopez for EOE, and I'm joined by attorney Alex Sahi. Thank you.
Thank you. And Deep?
Good afternoon. Susanna Nigro on behalf of the Department of Energy and Environmental Protection.
Thanks. Do we have any other parties or anyone else who wants to introduce? Oh, I'm sorry, Attorney General's office?
Yes, Carolyn McCormick on behalf of the Attorney General's office. Thank you.
Thank you. Anyone else? Okay. So like I said at the start, I just want to start with a overview to kind of inform everyone of the reason we scheduled this meeting. And thanks to everyone. I know we sent out this invite with not a lot of notice as compared to our normal invites, but hopefully everyone understands what we're here to talk about is how to handle scheduling constraints. So we didn't really have a lot of time to to schedule this discussion. So as everyone here knows, I think we had a scheduling conference in January. We discussed at that time the kind of competing views of some of the parties with respect to the amount of time necessary to litigate this case. After that, the commissioners tried to come up with a procedural schedule that attempted to find some kind of balance between people's various scheduling need. And I got to say that included PURA staff, who frankly weren't, the commissioners sort of had to overrule PURA staff also on their preferred amount of time to issue interrogatories, et cetera. So I imagine the schedule we issued resulted in mixed feelings for everyone because no one got exactly what they wanted. And maybe that's the way this is supposed to work. And since then, I think as everyone knows, the parties and interveners have been issuing a lot of interrogatories to Eversource, and Eversource has struggled with responding to those within the schedule we've created. And the commissioners have been seeing the back and forth between the parties via motions and correspondence, et cetera, filed in the docket. And I think I speak for all of us when I say we understand everyone's varying perspectives on this. And maybe for the sake of making this a more efficient conversation, I'll just walk through that understanding. Hopefully, if I'm capturing sort of every view of this or most views of this correctly, we can just avoid everyone having to say it themselves because I want to just communicate. I think we get where a lot of people are coming from. So it's my general understanding that OCC, EOE, and PURA staff are generally in a situation where they feel they might not have the information they need in order to engage in the hearings that are currently starting on March 24th in time. And I think their one proposed solution is to adjust the procedural schedule in one way or the other to allow for more time to review discovery and potentially issue follow-up and prepare for the hearing. But it's also my understanding that Eversource has been working hard and trying to respond to a huge number of interrogatories on time. And this is a understandable resource limitation for them. It's also my understanding, and Eversource points out correctly, that all parties and PURA staff had over a year prior to this point to issue any interrogatories anyone wanted in the now closed uncontested docket. I read Eversource's position to be that and I don't disagree kind of conceptually, a case could be explored forever. We could issue interrogatories for the next 5 years on this case, but at some point we've got to actually get to the hearing. I think all the commissioners, recognize that reality. On the other hand, it's my understanding that because the hearing dates in the prior uncontested docket were scheduled so far out in advance, the parties, meaning OCC, EOE, and PURA staff, understandably and reasonably were not prioritizing issuing discovery in this case immediately in the time frame immediately prior to the scheduling change, especially because we had 2 simultaneous rate cases going on up here at that time, a number of other proceedings. So again, I just say all that in the hopes that it relieves people's feeling that it's necessary to say the same things. People can feel free to say whatever they want, but we get all of that. The commissioners get all of that, and we are really just here today to figure out how do we navigate this in a fairly, it's true, we gotta have a hearing in this case. We have to get to one eventually. We want to make sure everyone has what they feel they need in order to get through that hearing. I think, frankly, if people don't feel like they have what they need in terms of discovery, then we're going to end up having hearings where people feel like we're going to need to extend the hearing dates potentially. So, there are a myriad of kind of moving parts here that we're trying to navigate. And it's important for everyone to get the information they feel like they need. Also, though, I think, we commissioners recognize Eversource has had the goalposts moved on them several times over the years, like with respect to these storm costs. And I think understandably is of the position where, their perspective is also not lost on us, that we can't just keep moving goalposts forever, meaning scheduled dates. So again, we've invited everyone here today this is a really hard problem for us to solve, so you guys got to solve it for us. We're here open to proposals and discussion about what it is we can do to get to this hearing, and be able to facilitate this. I do want to give one last update on behalf of PURA staff, because part of what's awkward about this and true of all kind of contested cases is that, when PURA staff has discovery issues, they don't have the tools available even to the other advocates, meaning like they can't just call up Eversource and say, hey, when we issued that interrogatory, thanks for the response, it was filed timely, but we actually meant this other thing. Like we can't have that phone call, right? So we got to issue a follow-up interrogatory, and that kind of creates additional lag. So that was an issue for PURA staff, specifically with an interrogatory RSR 99. The response to that was filed on time. And I want to make clear, I should have said this at the start, it's not our understanding, the commissioner's understanding, that anyone's acting in any bad faith one way or the other here. Like that's not, we're not viewing this that way. And same with respect to the company's initial response to that interrogatory. But the reality was we needed to ask clarifying questions about it. We needed more information. And now PURA staff is at a point where they're about 10 days. They've got what they need with respect to that response now, about 10 days after they hoped to have it. Now they need to issue follow-up interrogatories. So I just said all that to say, in light of the fact that staff can't be here saying that themselves as part of this meeting, that's sort of where PURA staff is also. So all that said, I thought maybe we could just start with Eversource. Eversource did reach out to the case coordinator and let us know that they had some I think documents they wanted to kind of put up on the screen, and presumably had something to kind of discuss. Is that correct, Attorney Pace?
Well, Chairman Wheel, in light of the comments that you made, I don't want to repeat points that we've made. And actually, what we'd like, and first of all, thank you for convening this to see if we can find a solution to the issue that you raised. I think maybe if it's amenable to you, we could hear from the parties who are looking for something, some type of relief, and maybe hear them out. And once Mr. Horton and I have had a chance to hear them out, we can maybe offer some suggestions for the commissioner's consideration to see if there's a way to address their concerns. So if that works with you, maybe we can start with the other parties and hear what their concerns are, and then we can propose some solutions.
Sure, that works for me. If it works for the other parties, maybe OCC, I can put you guys on the spot.
Kim White, OCC. So I have two different thoughts on that. Number one is it would help us to know, so we're getting the updates from Eversource every day, and we appreciate those, that tell us the number of the status of the interrogatories kind of in three different buckets. I believe off the top of my head, as of this morning, there were 109 outstanding interrogatories. So one of the things that would help us would be to know whether or not they think they're going to complete those 109 outstanding responses by March 10th. That would have been the original due date for all of them. So knowing that would help us understand a little bit going forward. I'll stop there. That would help us.
Yeah, I can respond to that question. So we did talk to the team in advance of preparing for this hearing, and you are correct. And I'm looking at the matrix right here in front of me that as of this morning, all questions that are due that have been filed, that leaves 109. A few of those are going to be due tomorrow, and then the remainder will be due on the 10th. The team meets every single day. We have a cross-functional team, including meeting on the weekends as necessary, and the team is going to get them filed by the 10th.
Okay, so once again, Kim White, OCC. If I understand that correctly, then all outstanding interrogatories would be filed by the 10th. That kind of leaves us with, I think, returning to what you said, Chairman, the ability to do follow-up and things like that. We had issued or we had filed a motion requesting an extension of the discovery schedule. We tried to, in the motion, absorb most of it ourselves from our perspective. I imagine from Eversource's perspective that might not be entirely correct, but we attempted to do that and just extend it a week. We didn't try to change the hearing dates because it was our understanding that those were very difficult to change based on PURA's schedule. We didn't get a ruling on that motion, so therefore we haven't issued that discovery yet. So there would be a little bit more discovery that we know we could issue, and we also have the thing you mentioned where we're not going to have the opportunity to follow up on some of these questions. So that could spill over into the hearings from our perspective.
Thanks. And I should have started at the outset saying that we did see OCC's motion and we hadn't ruled on it. This is similar to like the last scheduling conference where it was the same posture. I think we had a motion before us and we just weren't sure kind of how to rule on the motion without sort of figuring this out. Because I think, and I don't want to speak for the full panel, and obviously like we will rule on the motion, but at least from my perspective, granting OCC the relief it was requesting might still not work for the other parties who are also having scheduling issues and maybe also not for PURA staff. So that's sort of why we did that. And I apologize, we probably should have issued something from my perspective, at least again, without ruling on the motion from the bench unilaterally. I think it probably makes sense to just go ahead and issue those interrogatories if you know what you need now. I think this goes for anyone. Like we should get that out there and just to avoid even further delay caused by holding them, right? I mean, does that make sense to you, Attorney White?
Yes, thank you.
And Chairman Wheel, if I could reply on behalf of Eversource, and it's our intent to try and work with people. We know it's challenging for everybody. We want to try and hold to the hearings because, as you pointed out, we've had the discovery deadline move 4 times, and we've been planning in preparation for these hearings. We've told our witnesses to block off those dates. We have a number of witnesses plus all of their support personnel, and we've said to them as soon as the schedule came out, block off those dates, be available. We're planning around it. And we're happy to take additional questions. Now, if we get a question that asks for 500,000 lines of data, can we produce it in 5 business days? I can't guarantee that, but we'll keep doing what we are, which is doing our level best to try and get it as soon as we can. So if parties do have other questions, submit them to us, and we will do our level best to get you as much information as we can. But our request would be, let's keep the hearings where they are and start on that date, and we will provide as much as we can up through the start of hearings. And then if we have additional questions, we'll take those in the hearing room. We can provide late file exhibits.
Thanks, Attorney Pace. And I mean, speaking again only for myself, I had a similar thought. Like that does seem like an easy first place to start is we've got hearing dates scheduled. Everyone here knows how much scheduling work that takes. And you know, yeah, it seems like a waste to just not use those hearing dates and sort of shift the entire thing forward if there's work we can do with what we have on the schedule now. So, I mean, that's the way I view it. It does sort of beg the question, though. I mean, I recall a filing from Eversource, and I think I acknowledged sort of at the last scheduling conference, part of how we got here, Eversource, sort of started with an initial request for that resulted in a final decision date that was much too soon for Pura to accommodate. And then there was, I recall, a bunch of back and forth between the parties, and I do acknowledge Eversource moved that proposed final date a bunch of times, like conceded, kind of was willing to kind of move that forward in time, and landed on, I believe, August 1st was sort of like my understanding based on the last thing we saw, and we, when we were looking at issuing the last procedural schedule, was that August 1st was sort of like the best and last absolute latest Eversource could possibly live with a final decision in this case. And I guess first, like, it would be helpful if Eversource is willing to speak to this. It would be helpful for the commissioners to understand why that is. I mean, like, we can understand and appreciate the concessions that the company's made up to this point. We get the whole history, but if there is a really great reason why we should be really concerned about exceeding that August 1st date, that would be helpful for us for the context of this decision we have to make, if that makes sense. So can Eversource speak to that at all?
This is Doug Horton. I can start, and Attorney Pace, please supplement. I appreciate the question. I appreciate, as Vincent did, you calling this, Chairman. And I agree with how you characterized our initial position. I think a couple things that I would add, though, is when we talked about the schedule before, we see a number of things aligning for our customers next year that are beneficial to our customers if we can align them in this room. So we know there's a rate case coming, there's a RAM rate change coming. These things are happening in separate proceedings, but they will all impact our customers in the end. Securitization is another thing that's happening, and it's an extensive and involved process that can't begin until we have that decision in this case. So this decision becomes the critical path for us to be able to proceed with securitization, which again is another customer tool that we are looking forward to utilizing, but we can't get started in earnest until we have the decision in this case. So that's the critical path item. And I know this is a matter of substance for the hearings and a matter of dispute among the parties, but carrying charges are accruing, and they are real in a material way at $7 million a month. So from our perspective, it's imperative that if we can shift within a schedule, and Vincent mentioned some ideas that we have, and I completely agree, we want all the questions that you have, realizing it takes time for us to answer them, and it's the same people who are not only preparing for hearings that are answering them, but also having to respond to the weather events that we're here to investigate. So, there are other distractions and considerations in terms of our ability to respond in an expedient time frame. But we want your questions, and it would be much more efficient for all of us if we can answer discovery questions through discovery rather than having you all have to ask us discovery on the stand, which can be very awkward and silent. So we want the questions. I think we are very, very interested in accommodating schedule adjustments within the schedule as much as we can, keeping to the schedule as much as we can, and certainly keeping to that end date as much as we can, for the reasons that I just said.
Thanks. Yeah, and in case I think I forgot to say this part out loud, but the reason I was asking about the end date is getting back to Attorney Pace's point about if there's a way we can use the hearing dates we have now and just sort of add more hearing dates if necessary. Like I said, that conceptually makes sense to me, but it's hard to envision that not putting pressure on the current final decision date, which is sort of designed like that's the end date. We designed the current schedule around like what we would need on our end to process the information here, and get to the sufficient time for us to develop a decision and deliberate and all of that stuff. So you know what I'm saying? Like if we add a week of hearings, that puts pressure on that 8/1 date, like and that's why I asked that question. But I also wanted to ask as a follow-up for securitization. I totally understand that one idea that we've sort of been kicking around, I'll credit Commissioner Beecher and hope she doesn't get mad at me for just calling her out on this, is would it help just for procedural efficiency? I think we could conceptually, just throwing out there, we could open a financing docket today to create that docket. And that would at least start the deadline on people entering their appearances. Like there is sort of a lag associated with like starting a docket and then actually being able to do anything in that docket. So conceptually, if that docket existed such that it was ready enough so that we could, as fast as possible, sort of jump from the ultimate number that's in the final decision that's issued in this docket and shift that over to that other docket as soon, rather than waiting until we're done here and then saying, okay, now a week later, we're issuing a financing order docket, and in 3 months, we're going to have a scheduling conference on that. I guess what I'm ultimately asking is, in Eversource's sort of calculations for the amount of time it'll take to get securitization going, would that idea kind of make that, enhance those calculations, if that makes sense?
Well, I think that's a good point, but the time constraint that we have is actually not Pura's time constraint. We are engaging as best we can. We're starting the process, have started the process to do as much work as we possibly can to push securitization forward so that when we get that final prudent number that can be securitized, we are as far along as we can. So I would say, I guess the answer to your question is yes, if Pura has similar actions that it can take now so that when it's ready to receive that financing application, so be it. And I think that would be good, but on the margin, because the work that we see is in order to get that financing application ready, there's engagement with external bankers, rating agency reviews, legal analysis, not much of which is dependent on having that dollar amount. We can't do it until we have that dollar amount. We have to do, there's a lot of internal data that's required for us to produce to show determinate information so that sensitivities can be run on sales volumes and rate impacts associated with those sales volumes. There's a lot of work that goes into that process so that we can get the AAA rating. That's nothing to do with Pura's scheduling, although it would help to have Pura ready to accept that application. Our concern is the lion's share of the work can't begin until we have that dollar amount, which is why it's so critical to have that dollar amount coming out of this proceeding, inclusive of the storm costs and associated carrying charges, so that we can proceed with securitization in the end. That's the critical path for us. And that's why having it August 1st, I forget the exact sequence that we talked about at our last scheduling conference, but we get the decision August 1st, and it takes us 3 months. We're trying to wring out every day that we can from that schedule, but 3 months is our experience. So we get that 3 months, then Pura has 120 days for its financing decision, which would mean that's whatever it is, 7 months from August 1st, which gets us a decision just prior to our expected CLMP rate case decision. And so not saying that as cleanly and clearly as I once had it in my mind, but those are the things that we are all trying to align, and including with the RAM rate making decision that will happen next May 1st. So we're all these things coming together and seeing urgency to move and to keep that end date August 1st for this proceeding.
Okay, thanks. That's really helpful. So I guess, and I don't want to be dominating this meeting, but I guess the ultimate question then is like getting back to the hypothetical of one option would be to maintain the schedule we have now. People can, we can start these hearings on the scheduled starting date. We can use up all those hearing dates and sort of see where we are if we need more time to kind of get through the rest of whatever comes up. If we do, though, let's say hypothetically we need 6 more days, what tool can we use on our end to say, I mean, that's just, that means I'm staying up all night for 6 days, I guess, to I don't know how, the amount of time we have on the other end at Pura of post hearing when the record's closed, we need a certain amount of time to be able for staff to kind of put stuff together and analyze what's in the record, advise the commission. We have to have lots of meetings. I'm sure it's important to everyone in this room that the commissioners have plenty of time to deliberate and talk about all these issues. This takes time, and the amount of time it takes is what we put into the schedule. So, if the amount of time that's in the schedule is squeezed by a week, I don't know what to do with that. But again, I'm open to ideas for how we could resolve that issue on our end. Sure, Mr. Horton.
I may have raised my hand premature because I don't know that I can offer a solution except to say it might be helpful to just take it step by step into C and not try to solve the problem that may not come. I have no idea how the hearings are going to go. If we're going to need all 6 or 7 days that we have scheduled and completely, and we're going to I don't at Eversource we have no sense of how much or how little of that time is going to be necessary to know, whether extensions or additional days are needed. And also, we just acknowledge, and of course, I understand, parties are having to review the responses that we're putting in and have some concerns with the extensions that we've needed for those, but we aren't even at the end of the deadline yet. So there are still, we have every intention and plan to have the responses in by the 10th, which is the end of discovery. We are, as Vincent said, willing to take on additional questions, send them. We'll answer them as quickly as we possibly can. And we can talk about some other ideas that we have to help to work together to try to make an efficient hearing. That's all of our objective, but we're not at the end of the discovery yet. We expect to get another 20 or so in tomorrow, and the lion's share in by Monday, Tuesday being the 10th. So it's hard for me to sit here and say that we should be, I agree with you, Chairman. I think we should be using the dates that we have on the schedule, not extending until we see there being a need to. And I think then we'll just have to have a similar discussion as to what really is necessary, provided that there is a lot of work for the commission and its staff on the back end to issue a decision. But sitting here right now, it's just hard. It's hard to anticipate how we should adjust the schedule, not knowing what we even need to accommodate for additional days or what have you.
Chairman, if I could add too, and again, we appreciate the fact that the commissioners are giving us an audience to offer our views. I realize you all have the tough job of trying to balance all the competing concerns that you have. We feel very strongly here at Eversource that we should proceed to start the hearings on schedule. We filed 1,571 data responses. We expect that the remaining 109 in on time next week, and we've committed to answer more. One other tool in the commissioner's toolbox could be to deal with the valid points that you raised would be once we get through the first group of hearings, there could be another scheduling conference where the authority says, based on how this is going, we think we can stick with the schedule or we have to make some further tweaks, and here's what they are. But at least we'd have a chance to get into the hearings and get through those days, and then can take stock of, does the authority think we need to make further adjustments or hold to the schedule that you have? So we're asking the authority to consider that kind of step-by-step approach. We will take questions up to the start of hearings. If we could start the hearings as scheduled, and then the authority can revisit the schedule after we get through the initial round of hearings. So thank you for the chance to offer those thoughts. Other things that we can offer that may be helpful to people would be if people would like, for example, a hearing roadmap where we can organize the questions we filed by category. If that would be helpful to people, we're happy to do that. If you need us to create hard copy compilations of data responses for the PURA staff to save people a step, we're happy to do something like that. If you want us to put together for your consideration and the party's consideration a hearing schedule that talks about what topics could be covered by day, we're happy to do all those things to help make the hearing process more manageable for people, because we get it. It's a lot of work for people to get ready for hearings. Those are things that we can definitely do to maybe try and make it a little bit easier for everybody. We're happy to do those things.
Thanks. I just want to give, I wasn't sure if Attorney White, if OCC had anything else to say, and I wanted to give everyone else a chance, EOE and Deep and AG's office.
Thank you, Kim White, OCC. I actually had a question for Mr. Horton based on what he was saying. Just from my understanding, when he was talking about the securitization and the time frame, is Eversource presuming that they're doing the securitization themselves, or are they using the Treasury for that?
We are assuming that we are, well, I can't speak to the specific mechanics of it. I know that the Treasury there's some reference to it in the legislation. So my expectation is that we will be proceeding and following the law, but I don't know the Treasury's office involvement, frankly.
I'm sorry. I'll let Consumer Counsel come and go.
Sure. I was just going to jump in and response to Mr. Horton's comments on that. I mean, I think the statute is pretty explicit that PURA has the authority to determine what's in the best interest, whether it's Eversource or Treasury. So it would seem like with all of these synchronization issues, perhaps discussing how to make that determination earlier rather than later would benefit everyone.
Yeah, so maybe getting back to the idea I blamed on Commissioner Beecher. I mean, maybe I don't see why that isn't. I mean, that's a determination we would make in the financing docket, but yeah. I mean, I guess if anyone correct me if I'm wrong. Well, yeah. I was about to say I don't know that we need the final number in this case to make that determination, but I think we do, right? Like we think we like a question before us is like the scope of like the overall materiality of how much money we're talking about here. I think in order to ultimately make that determination, we need to kind of get a sense of the comparative cost, like the comparative ultimate rate impact of the CTA through the competing models of whether it's Treasury or Eversource actually issuing bonds. But am I getting that? Someone want to correct me on that?
So I don't have firsthand experience myself. I think that in the end, whether it's the Treasury's office has some involvement or not, it's still the same AAA rated bond. And so I don't know that there's any, I just don't know that there's any benefit of involving the Treasurer's office. But having said that, I'm not prepared today to speak to how the law contemplates the Treasurer's involvement or not. If it is subject to PURA's discretion and decision, then I completely agree. I think we would want to know what or how that would implicate the process sooner than later, because I think otherwise we would be potentially pursuing redundant steps if we're not going to have some involvement that we think that we would. So that might be something, but I would need to have others on our team available to speak to that. So, but that's perhaps something that we could do in parallel here and in advance of this decision coming out.
Yeah, just speaking off the cuff, that does sound. It sounds like to me what might make sense, maybe in addition to the discussion we've already having, is if we were hypothetically to open that other docket and try to schedule some sort of technical meeting where we invite Treasury to, at least get the ball rolling on figuring out the mechanics of how this would work, and maybe figure out even the questions that ultimately do need to be determined by PURA, because it does seem like that the answers to those questions might impact, the ultimate timing on your end, and like you just said, we also don't want you guys doing a bunch of work and then realizing you didn't have to do it, right? So
yeah.
Commissioner Beecher, I think I saw you come off mute.
Yeah, so I don't know if this is a valid question or not, but would multiple tranches affect how we would think about that as well? Because, that's another aspect to this, I would suspect.
I think you're saying the structure of the securitization financing, whether it be in multiple tranches or not. I think that we anticipated that it would, but at the same time, I think I'm agreeing, Chairman Wheel, that perhaps a separate discussion, targeted discussion on exactly what would need to precede the securitization financing application would be in order. And I'm not prepared to speak to that today, but I think that would be a good use of our time, exactly to what we just said, and including if, how do we determine the number of tranches? My expectation and understanding had been that we would be preparing that filing and then presenting that to PURA, inclusive of our plan for the number of tranches, how it would be structured, the terms, et cetera, would all be part of that financing application and review by PURA. But if there's things that need to be decided before that, or PURA is expecting to weigh in on before that, or the law requires PURA to, then I absolutely think we should be doing that now. It's a great suggestion.
I mean, it's because only the last one has to get you to the right number.
That's true. Just mathematically, I guess. Commissioner Smith.
Yeah, I was just going to jump in and, listening to this, it just seems to me that the two things that might help the situation is if we can find a way to dual track the process and put all the financing securitization in another track and get a subgroup or however PURA does it. I like to tell everybody I'm new. I'm going to do that for years, so get used to it. But get on two tracks, and then let's also examine how can we shrink the back end of this process. There's got to be ways. I've done a lot of financings in my life, and there's got to be ways to shortcut it. And I'll tell you, the bankers will move heaven and earth to get the bonus moved into this year. So, I just think dual track it and let's try to shorten the back end. And I know that's not a solution. It's just a observation.
Thanks. I'm going to call out my former mentor, Mr. Sobolewski, who just entered the chat, because I think he might be the only person in this room who's been through this, but I don't want to speak for anyone else. But I was wondering if Mr. Sobolewski, if I can put you on the spot, if you're still here, if you can give a rough estimate of what you've seen for securitization finance proceedings in terms of how long they took.
From the proceedings at Pura themselves were not that long per se. You know, you had a couple days, you know, a day here, then the second day hearing, and then I think one at the end after everything was in place to make sure, you know, everything matched up to what was previously allowed, you know, to make sure that the terms you approved originally were the terms at the end, you know, but it's, you know, it's a little more than the normal financing at before Pura, you know, any of the bond issuances or what have you. It's a little more complicated, and then you have more parties. And if you have the treasurer's office and you have them, and then you have someone from the outside, the underwriters and everyone else come in. So it's, you know, it's probably a little more complicated in that you have, you know, things you don't necessarily handle in a normal financing proceeding before Pura. And then it's just to make sure that, you know, Pura is going to have the dedicated, you know, revenue stream to fund the bonds. And there's, you know, everyone signing off, the utility signing off that, yep, that this is all right, this works, and everyone else signing off that the deal works.
Thanks. And to clarify, I meant Mr. Sobolewski, I think you're the one who has the experience under our statute here in Connecticut doing this before. I know Mr. Horton has been through this in other jurisdictions. Can I just ask as a follow-up though, Mr. Sobolewski, do you roughly remember like how long a gap in time it may have been totally roughly between Pura determining a final number that needed to be financed and when like a utility actually got the check? Like I think that's
It's probably a 3 or 4 month period, you know, but those were smaller. Well, other than the first one, when it was the stranded cost, that was, you know, that was $1 billion type of deal. But the other ones were smaller in the couple hundred million range. So the stranded cost one was more because it was much more tied to other dockets before Pura, you know. What, you know, so my memory on that from 20 something years ago isn't as clear about, you know, what came first, you know, and how the interplay was between those, you know, all those restructuring dockets.
Thank you. We're just trying to, you know, suck as much out of you as we can while you're still around. So thank you. I appreciate you speaking on the spot. Mr. Horton, I see your hand.
I just wanted to just respond to some of the comments and to say that again, I think we are completely aligned with the objective to streamline that process as much as we can. We had presented a timeline that indicates that from the date of prudency, it could be as much as 12 to 16 months. But like I said, we are motivated, aligned, and all in on making that as quick as possible. I do think, just to be clear, I have always saw it as a dual track thing, meaning one track is to get this storm prudency decision in one track, and then the securitization by necessity is in a separate track. We're not going to be able to go to securitization. I see you nodding, Chairman. That's like the securitization is going to be in a separate track, but maybe as a way just to, we would be completely supportive and perhaps recommend that we have a technical session where we can have the right folks and do some additional research on our end so that either I can be more prepared to speak to exactly these pieces and sequences and how it fits with the Treasury, et cetera, at a separate session. But with that goal in mind is making sure that the securitization track can happen as quickly and efficiently as possible.
Yeah, and just to confirm where we're at Pura, the scope of this docket from our perspective is just the question of what prudent recovery is allowable among, like, within the application. That's the answer. We're going to issue in this docket. And then there's the question, I don't mean then sequentially, I mean as a separate question, how does, you know, I guess first, whether it's appropriate to finance that through securitization, and then also how, and us actually facilitating that financing is a separate, like that's a, we've been envisioning that as happening in a different proceeding. I guess we were sort of just clunkily, I don't think there was a plan necessarily. We don't have an internal schedule thinking, saying, okay, after the current scheduled final decision date in this docket, we're going to issue another docket. I think it was just sort of, I think we were just all been sort of focused on getting this answered first, because we ultimately need that number in order to do the second, to do the financing. But as it was Commissioner Beecher again, who sort of highlighted like, well, why don't we don't need all of that to start that second process. So anyway, I just wanted to confirm we were not envisioning, we were envisioning these as sort of two separate questions. So I agree. Attorney.
Yeah, I did just want to have one clarifying question for the record. I did not interpret the comments we had heard earlier today mean that the treasurer must be involved in the process, because while we were having this discussion, I looked at Senate Bill number 4, and I looked at the section that talks about, while the word financing authority does mean the state acting through the office of the treasurer, when I looked at revised subsection 11, you know, as many other parties on the call know, it says that in the case of rate reduction bonds to recover financed utility services, which would be the storm costs, it would be the entity authorized by PURA pursuant to your issuance of a financing order, and that could include a special purpose trust or other entity that's, you know, identified in the application we submit to you. So I just wanted to clarify that I don't read it to mean that it's a fait accompli, that it must be the treasurer. I read it to mean that the authority in the context of adjudicating a request for a financing order would decide which entity would be issuing those bonds. So I just wanted to make sure that at least our position was clear on that for the record. Thank you.
Thank you. That's helpful to know. Attorney White, were you all set? Was OCC all set before I put anyone else on the spot?
Yes, regarding the current topic of discussion. We might circle back to some of the things that happened at the beginning, at the end.
Okay. EOE, Attorney Lopez, do you have any?
No, I think what generally was proposed made sense. You know, with the understanding that if the discovery responses are complete by March 10th, notwithstanding new questions or anything of that nature, but if everything outstanding is in by the 10th, then I agree that it makes sense to proceed with the hearings as scheduled. So I will leave it there without taking up too much of anyone else's time. That being said, I mean, maybe just briefly, if that doesn't happen to be the case, obviously, we would want to reserve our rights there. If you know, on the 10th, there's still, you know, 25 remaining outstanding discovery responses. I'm not so certain then about, you know, it sounds good now, but you know, I just leave that as a note. But that's all I have. Thank you.
Thanks. Attorney Nigro, anything from Deep to add?
I don't have anything further to add. I think what's being proposed makes sense.
Okay.
Thank you.
Attorney McCormick.
Nothing further to add.
Okay. Commissioners, any other? I mean, I'm not wrapping it up, but just making sure everyone's. I mean, so to be clear, where I'm at now, where we ultimately do need to determine sort of the path forward and how to respond to how to rule on OCC's motion, and whether, I guess, it's necessary to adjust the schedule, taking into account everything that everyone's discussed here today. I'm curious if anyone has, it does make sense to me, not to hide the ball, Mr. Horton's suggestion, I'm sorry, I can't remember if it was Mr. Horton or Attorney Pacer, both suggestion of sort of, what if we just leave the schedule in place for now, and if we arrive at a place where it's clear at that time, now we can't do this, then we reconsider. Does anyone have a specific concern with that proposal? Okay. Attorney White, you said you might want to circle back on something.
And White, OCC. At the beginning, there was a non-ruling from the bench regarding our motion. I just wanted to clarify, if we were to issue the interrogatories now, are we still working with the due date we proposed in our motion, or is that what should we just assume that and go with that?
I think like I would kind of bounce that back to maybe Mr. Horton and maybe Attorney Pace. My understanding of where Eversource is at right now is that if you get new interrogatories, like that you're still willing to respond to those even beyond the rolling discovery date. Is that inaccurate?
Yeah, I mean, despite the fact that my team will revolt, yes, we want to answer all questions that you have, and we want to facilitate as best we can an efficient hearing process. And we've been through hearings that aren't as efficient because discovery, questions that could have been asked in discovery are asked at hearing, and then everything is clunky. So if you can issue the questions, we will do our level best to answer them as quickly as we can. I can't guarantee we can make, I don't know what the date was in the motion. I can't sit here now and assure you that I'll have it in by any date certain without seeing the question and the amount of research that goes into answering fully. But we will endeavor to do our best and to provide responses whenever they're asked.
Thanks. And yeah, I don't want to speak for OCC, but I think I recall the proposal in the motion generally was shifting the rolling discovery due date forward in time, but not changing the hearing date. And I guess the reason I asked the question I did is it sounds like, it might not even be, depending on sort of where we're at in terms of outstanding discovery, it might be possible that there might be one or two responses that the company might need, like, where that even OCC's proposed date might not be soon enough. Like we might be halfway through the hearing and then a discovery response comes in within reason, of course. I do want to emphasize we're not inviting people to abuse the system and start issuing interrogatories to Eversource one day before the record closes. Like that's any party could feel free to file an objection to that based on reasonable objections. Just for, again, in the spirit of trying to figure this out mechanically, I guess getting back to Attorney White, I think that's the reason I'm personally like hesitant to kind of fix in time as where I sit right now. Yeah, let's shift the rolling discovery date to this date certain. I'm just worried we're just going to run into the same mechanical problem we have now, of now if we just had one more day, then we would be able to get past this. But since the discovery date is fixed in time, we can't do that. I guess I'm concerned about that.
And that's understandable. Oh, I'm sorry. That's understandable. So we get that. I guess our only counter concern would just be, if we're receiving a lot of discovery in March 23rd, that puts us in a particularly bad position going into the hearing. So we're trying to balance things as best we can. But
yeah,
from our perspective, based on what we've heard here today, we'll issue the discovery. We'll keep the due date as we said, and if hopefully it comes in within a reasonable time. And if it doesn't, I'm sure we will be happy to file an objection.
And Attorney White and Chairman Wheel, a solution to Attorney White's hypothetical would be, if we were to file something too close in time to the hearing, we make it a late file. So that way, those become late file exhibits and you have more time to prepare your cross, and we produce a panel at the late file hearing. So we want to try and work with people because we understand it's a lot of work to get ready for a hearing. So we're going to take the questions, and as Attorney Horton said, we'll do our level best to answer as many as we can. And then if you feel like they're too close to the hearing date, raise it with us. And then we can see if there's a solution there that we can present to the commissioners.
Yeah, and I was going to say, I do see the other hands. It seems to me that the general proposal too is that in some nightmare hypothetical where as of April 2nd, which I'm seeing is the last day of normal hearing, if there's 500 new interrogatory responses that come in at that time, I think that would be grounds to have this, we could have the discussion that I think Eversource is proposing. Maybe that would be a reason to have a discussion of like, is it possible given the current procedural schedule to actually get this done, or do we need to add dates? Like, I think that's the idea. Am I getting that right from sort of everyone at the table? Of it's true this might not work, but the kind of relief valve for that is that we can have a discussion like this if things don't work. Is that generally right? Okay. I think Mr. Horton, you were before Ms. White. I don't have the thing where I can see who raised their hands first.
I think I was only going to just to build off what Vincent said, and I think he inadvertently promoted me to an attorney, which is a very big day for me. But
and I demoted Attorney White to a non-attorney at the same sentence.
But I was just going to say, in addition, like we will answer. I certainly hope we don't get 500 on the day before here, but I understand the point. We will answer whatever questions we can as quickly as we can. I just was only going to comment too. We're in a rolling mode, so if we have an answer that we can submit and it's early, we're doing that. It isn't like we're holding and then, only filing things late. So as soon as we're able to answer any question that we receive, we'll do that as quickly as possible.
Attorney White, Esquire. I see your hand.
Kim White, OCC. I appreciate the discussion, and we are certainly willing to work with everything that's been said. I guess I just wanted to address the one thing that Attorney Pace had said regarding using them in the late file hearings. That obviously, when that occurs, if that occurs on a large basis or depending on the interrogatory, then that deprives us of the ability to ask for late files and or get more information. So we're just trying to highlight that we need to balance some things here.
Yeah, I for one recognize that's a thing that's happened in the past that I've seen myself, is that like if you shift kind of the questions, the cross that would normally take place in a regular hearing to a late file hearing, what inevitably ends up happening is now you want a late file that you're asking for in the late file hearing. But again, I think if that happens, then the relief valve for that is that we have another one of these conversations. So. All right, anybody else? Did we somehow get through this without anybody like yelling at each other? Okay, well, I want to thank everyone. This has been really helpful for me, at least. Like I said, we sort of went into this not really being sure what to do, and I think we have helpful information now to discuss, and we will issue a ruling on OCC's motion. And I am just going to go ahead and rule from the bench until you go ahead and issue those interrogatories. Please don't wait for us, based on the discussion we've had today. Yeah, so I guess that would be the kind of next procedural step as a result of this conference, is we will issue a ruling on that motion, and until we do so, then obviously we're not going to rule from the bench on anything else today. I see Mr. Horton.
Chairman Will, I apologize because you were just wrapping and I might extend, but I did want to offer one other idea as we're proceeding through this, which is that you mentioned with respect to RSR 99 in particular, that it's difficult because it's a contested proceeding. Parties are not able to just pick up the phone call, which despite the title I was given, I am not a lawyer, so I don't know all the rules of that. But one thing perhaps could work, given our compressed time frame, but potentially, is if we could have a cadence, if there is a need where a conversation could just resolve and clarify, even if it's on our end, something that we could answer more expeditiously. We can't just snap our fingers and get information in the format that's requested. Most times, frankly, it's not possible. So it's a manual, involved process. In other jurisdictions, what we can do is we'll have a technical session where the parties are all invited to come together and talk. I think it's generally off the record, but it can be on the record. And then that either results in a better understanding of what information can be provided or is being provided, and then other formal official discovery as follow-up, potentially or not, depending on how the technical session goes. And just as we were preparing for today, seeing the letter from Pura on RSR 99, that was one thing we had discussed, is it took us a lot to get to the format that we did. At the same time, if there are additional follow-up questions or what have you, maybe a technical session could be a forum that we could all parties participate in not violating any ex parte rules, and then have a conversation, in a way that would facilitate a more quick and efficient resolution, as opposed to a back and forth with the formal discovery. I'll just put that out there as a potential way. I know there's going to be scheduling challenges, but on some of these, it might not be so bad if there's only a handful of our people that we need to have there, as opposed to all 70 witnesses that we're aligning for a hearing date. But
thanks. I do appreciate that, and it's an annoying issue to me across the world in which we operate. That so much of my understanding of that issue was just sort of, it could have been so easily resolved with just sort of like, oh no, hey, could you please just make it look like this because that matters to us, and it's, you know, and I'm not, you know, it's because of the formality in which we have to address that, then it sort of feels, it just raises the temperature in ways that aren't necessary, and also causes delays, even more importantly. So I'd welcome, we will talk as commissioners generally and as an agency about adjustments we can make to kind of overcome that unnecessary formality and stiffness where it's just not, in some circumstances, isn't accomplishing anything other than just making everyone's lives harder. So thank you.
And yeah, sorry, in New Hampshire, this is the common practice. So each proceeding has that, it's built into the schedule. So I just offer that as something, if you're thinking about other changes, there's technical sessions built into the schedule that are just for that purpose, to talk about discovery, and then the process continues just like it does here. I find that to be a very effective way for us to just talk and explain, because often you can misunderstand what somebody was looking for or what was provided. It's natural. So thank you.
Thank you. Okay. Anyone else? Last call for anyone else who wants to jump in? Okay. Well, thank you, everybody. Like I said, we will rule on OCC's motion soon, and we will, unless we have to have another discussion, which would be fine, we will see you all in the hearing room on March 24th, pending any other reason that that's not true. So thank you. Thank you very much for your time today. I appreciate it.
Thank you.